Authorities can also engage in more collaborative procurement through joint working. There are clear benefits to inter-authority collaboration. For start, there's less opportunities for challenge, but there's also value in having centralised procurement expertise, which can reduce the scope for error. And of course, that's in addition to the shared costs, the economies of scale, the better cooperation in terms of transport links, logistics, and site availability that collaborative procurement can bring. Finally, it's important that authorities try and keep the process as simple as possible. The more complexity there is in the procurement process, the more likely it is to go wrong. And the complexity of solutions does not mean that the overall objectives of any particular service have to be complex. And it is possible to use output-based specifications to allow for a more efficient and less risky procurement. I have mentioned collaborative procurement, and of course by that I mean authorities working together to procure public contracts from the market. One of the natural side effects of the difficult procurement environment that exists is that public authorities are now looking more and more at the whole area of shared services and the opportunities to assist each other with the fulfilment of their waste management strategies, and this has already been alluded to a number of times today. I think in the waste sector there is particularly significant scope for this to occur, because the public authorities often have the ability and the capacity to perform waste collection, waste disposal, waste treatment services themselves, and therefore this means that they could provide those services to other authorities also. So in that respect, the waste sector is maybe unlike some other sectors where the public authorities don't have the necessary capacity and skills. Of course, the leading case on this horizontal cooperation is a waste case, the Hamburg waste case commissioned against Germany, which involved horizontal arrangements between local authorities, 4 local authorities outside Hamburg and the city of Hamburg. Those authorities agreed to provide their waste to the city and agreed to pay the city for its costs in the onward disposal of that waste. That contract was concluded directly without a competition, and the Commission complained that it was an illegal direct award. To cut a long story short, the court held that the arrangements were in fact lawful, and that the agreement did not have to be the subject of an award procedure. Now, there were a number of different elements that the court drew together to eventually come to that conclusion. Firstly, they considered that the authorities involved in that arrangement were involved in the joint execution of a public task, i.e. waste disposal, that all participating authorities had to perform. The court also considered that there was a certain reciprocity of obligations between the parties, and it was also significant that there were no financial transfers between the parties, other than a reimbursement of costs. So the city of Hamburg wasn't making any profit on this arrangement. The test that ultimately the court came up with was that cooperation between public authorities does not undermine the objective of the community rules on procurement, where the implementation of that cooperation is governed solely by considerations and requirements relating to the pursuit of objectives in the public interest, and where the principle of equal treatment is respected, so that no private undertaking is placed in a position of advantage vis-à-vis its competitors. So that was the test that the court in the Hamburg case came up with. It's not a particularly easy test to apply in practice, and one of the difficulties with that judgment is that the factors that kind of ultimately led the court to devise that test weren't particularly prioritised by the court. It's a little difficult to discern from the judgment which of those elements are the key elements or are more important than others. So it's a little bit unhelpful as a judgment when trying to advise awarding authorities. The Commission, European Commission, actually issued a staff working paper last October, which looked at some of these issues and I think quite helpfully added to the debate about horizontal cooperation. And it picked up on one particular point which I'd like to mention. That is the relevance of whether private undertakings are capable of providing the service that the service provider in that horizontal arrangement is providing. A question that occurred to me in advising clients post Hamburg was whether it was relevant that there are private undertakings who can do what the public authority providing the service is contracted to do, and that wasn't a question that was really addressed or had to be addressed in Hamburg, but it was picked up in the working paper, and the Commission was of the view that in order for there to be real cooperation, which is exempt from the directives, there cannot be a situation where one party is performing a task for another party for remuneration. The Commission said that a unilateral assignment of tasks by one authority to another cannot be considered as cooperation, and it went on to say that cooperation which is exempt from the procurement rules should only involve entities which are principally not active on the market with a commercial purpose. So that kind of pushed the debate forward a little. There was a further case, Asienne de Sanitaria case, which the Advocate General has reported on most recently in May. It has, I don't think a decision of the court has yet been issued, but I think for anyone interested in this area, this is an interesting opinion, and it does go a little bit beyond what the Hamburg case said, particularly on that point about whether it's an issue as to whether private entities are disadvantaged or not. The court said that one of the factors that led the court in that case to rule that the award of the contract was in fact illegal was that private entities could be disadvantaged by the arrangements, and that is to my mind that is a significant step beyond Hamburg, and it'll be interesting to see if the court picks up on that. Obviously, the new directive tries to codify some of the law in this area, and particularly in relation to horizontal cooperation, it has codified some of the factors that were raised in the Hamburg case. Although, to my mind, the position is still not entirely clear, and the draft directive is something of a missed opportunity, I think, to really provide certainty to the market in this area, particularly in relation to horizontal cooperation. So just to sum up on the issue of shared services, I think it's an area that is very relevant to the waste market, and I would expect there to be a lot of developments yet in this area, and I think that the waste sector will contribute probably disproportionately to the evolution of the law on shared services and more generally. Thank you very much.